Well, good morning, everyone. Today is May the 15th, 2024. We're here for this first of two public hearings regarding proposed rule changes around 19 TAC 89, sections 1005, 1075, 1085, 1090, 1092, and 1094. Before we get started, I have a couple of obviously we have a couple of things we got to take care of. And that is speakers will be called upon in order their sign-in number. Please clearly state and spell your full name. If you're representing an organization, please clearly state the name of the organization that you're representing. You will have 3 minutes to speak. The timer will start after you have stated your name and, if applicable, the name of the organization that you're representing. A 30-second warning will be given. At the end of the 3 minutes, you'll be given a signal to stop. Once the stop signal is given, you may complete your sentence and then you must stop. Speakers are encouraged to include a written copy of their prepared testimony, and written testimony can be emailed to spedrule@tea.texas.gov. I went ahead and put that in the chat for everybody. And then lastly, as always, TEA staff will not be responding to your comments today, nor will TEA staff ask or answer any questions. And so again, I just want to double check and make sure that the recording is on. So this will be available in a couple of days on the TEA YouTube channel. Our first person to provide testimony is Elizabeth Wilson.
Hello. Shall I start? My name is Elizabeth Wilson. And you need my address? Is that correct?
No, ma'am, you don't, unless you're representing an organization.
Texas Dyslexia Coalition. I would like to request an addition to address dyslexia in TAC 89.1055, which is focused on developing an individualized education program, IEP. All of the language is taken directly from the Dyslexia Handbook as requirements that the ARD committee must address. This language or other language with the same intent should be included in the same manner that 89.1055 provides specific IEP requirements for other disabilities. Currently, dyslexia is not mentioned in this section. Without this addition, this area of the handbook is unenforceable. H, for students with dyslexia and related disorders eligible under 89.1040 C9 of this title relating to the eligibility criteria, the IEP must also meet requirements of Dyslexia Handbook, Procedures Concerning Dyslexia and Related Disorders, TAC 19, TAC 74.28, as adopted by the State Board of Education and its subsequent amendments and guidance published by the Commissioner related to evidence-based dyslexia instruction, which is specially designed instruction. And we're proposing that it state that the ARD committee, when discussing how a student will access an LEA's evidence-based dyslexia program, must address the following. 1, how the program addresses the required components of dyslexia instruction described in the Dyslexia Handbook, and whether the student's PLAF or other areas of the IEP show evidence that the program must be supplemented with a focus on one or more components. 2, how the program addresses the required instructional delivery methods described in the Dyslexia Handbook, and whether the student's PLAF or other areas of the IEP show evidence that the program must be supplemented to meet the student's needs. 3, the fidelity statements, requirements that are included with the program and how those will be delivered and or intensified for the students. And finally, confirm that the provider of the dyslexia instruction, PDI, is fully trained in the instructional materials to implement the program and how to differentiate the program as determined by the ARD committee. Thank you for considering and including my request in the public feedback. I put it in the chat and I also emailed it because it's really just an excerpt from the handbook and it would be easier just to pull it from there. Thank you.
Thank you, ma'am. Okay. I see that Mr. Miller did not make. Okay, Mr. Miller did not make it back. So Mr. Allamon, you are the next registered speaker.
Okay. Well, good morning. My name is Stephen Aleman. That's STEVEN I'm representing Disability Rights Texas, the Protection and Advocacy Agency for People with Disabilities in Texas, including our students with disabilities in our Texas public school system. This morning, I'm making a few remarks highlighting our comments with regard to this most recent special education rule amendment package. To be clear, we will be submitting more comprehensive written comments, but this morning during this forum, I want to highlight 3 comments in particular. The rules I'm going to address are the proposed changes to section 89.1005 on instructional arrangements and settings, section 89.1092 on contracting for non-public residential placements, and section 89.1094 about contracting for non-public day placements. With regard to the proposed amendments to Title 19 Texas Administrative Code, section 89.1005 on instructional arrangements and settings, I have 2 comments specific to that rule. One is that in subsection C, it addresses the consideration by the ARD committee of the instructional day for a student with a disability, and some specifications are outlined in subsection C. Our request and recommendation is that TEA change this rule before final adoption and add a specific requirement that if the ARD committee is going to shorten the instructional day for a student with a disability, that must be explained in writing in the IEP, and an explanation for that reduction in the standard instructional day be explained. Our next comment with regard to section 89.1005 is with regard to the definition of a instructional placement that's currently referred to as state-supported living centers. TEA proposes to change the label of this instructional arrangement or setting to state school. We object to that change. We see no justification or basis for making that change. State-supported living centers should continue to be referred to as state-supported living centers, and this is located in subsection E11 in Rule 89.1005.
30 seconds.
My final comments are with regard to 89.1092 and 1094. They are the same, and that is that we ask that TEA add a requirement that any residential placement or non-public day school not allow aversive techniques as opposed by section 37.0023. Thank you.
Thank you very much. Okay. Let's see who snuck in right at the Ms. Stevens, are you interested in providing public testimony today?
Yes. Am I available to be heard? I'm sorry.
Yes, ma'am. I didn't get a chance to ask you as you came in. So
Yes. Perfect.
Okay.
Yes. Okay. Krista Stevens, CHRISTA, Stevens, STEVENS, State Government Affairs Director for Autism Speaks, resident of Texas. I don't need to go through with a comprehensive list of the concerns. Just want to echo what Steve Alaman stated previously in his testimony. Autism Speaks supports those same comments, and we'll be following up with written comments to reiterate that information. Thank you.
All right, thank you very much. Okay. There are no other speakers signed up to give public testimony today. I want to thank you all very much for attending today's public hearing. At this point, we're going to go ahead and conclude. And as a reminder, you can submit your written testimony via email to spedrule@tea.texas.gov. And a recording of this meeting will be available on TEA's YouTube channel in the next couple of days. Thank you all very much. Have a great day.